This is part 9 of torts, looking at warranties. You have express and implied warranties. Warranty action may be brought against all defendants in the chain. This is the manufacturer, distributor, seller. You have implied warranties. You have the implied warranty of merchantability, the implied warranty of fitness for a particular purpose. Implied warranty of merchantability is that the product is generally acceptable and reasonably fit for the ordinary purposes for which it is being sold. Merchantability, fit for ordinary purposes for which it is being sold. Implied warranty of fitness for a particular purpose, where the product is fit for that particular purpose. Here, the seller must know the particular purpose for which the product is being purchased. So the seller tries to sell you high heels when you want to go hiking. High heels are not fit for the purpose of hiking. So the seller must know the particular purpose for which the product is being purchased, and the buyer must rely on the seller's skill or judgment in supplying the product. Claims for implied warranties is a failure to live up to the warranty constitutes a breach. The plaintiff does not need to prove fault. The plaintiff may recover personal and or property damage as well as pure economic loss. That's implied warranties, merchantability and fitness for a particular purpose. You have express warranties. An express warranty is a guarantee, an affirmative act or promise made by the seller regarding the product that is the basis of the bargain. Now, the seller is liable for any breach regardless of fault. So where the seller forms an express warranty based off their act or promise, they are liable for any breach regardless of fault. Damages may be recovered for personal and or property damage. That's recoverable. Defenses to warranties. The disclaimers may be a defense to a warranty. You can generally disclaim warranties. With consumer goods, however, any limitation of consequential damages for personal injuries or injury is prima facie unconscionable. Defenses, you have the general tort defenses to warranties. You have the general tort defenses such as assumption of risk. Under the majority of jurisdictions, plaintiff's unreasonable voluntary encountering of a known product risk bars recovery. Comparative fault jurisdictions, majority reduce recovery. Contributory negligence jurisdiction, does not bar the claim, does when there is an assumption of risk. Tort defenses such as product misuse, and this is an implied warranty claims, prevents recovery in merchantability when the particular purpose is available. So that prevents recovery in merchantability when an action particular purpose is available. Moving on from products liability to defamation, invasion of privacy, and business torts. Looking at defamation, elements of defamation is defamatory language of or concerning the plaintiff, publication to a third party, damages. As a matter of public concern, the plaintiff, if the publication is of a matter of public concern, the plaintiff must prove fault on the part of the defendant. If the plaintiff is a public figure and or public official, the plaintiff must prove actual and or constitutional malice. That's New York Times malice, known or should have known, not common law malice. So it's a public official or public figure, as New York Times malice. Defamatory language is that language which diminishes respect, esteem, or goodwill towards the plaintiff, or that deters others from associating with the plaintiff. In regards to defamatory language of or concerning the plaintiff, this is where a reasonable person must believe that the language refers to the plaintiff. If the language concerns a group, any member of the group may proceed in a defamation action. You must defamation is defamatory language of or concerning P. You have publication of a third party. In regards to publication, this may be intentional or negligent communication to a third party. a republisher is liable as a first publisher. So you hear a nasty rumor, you spread it, just as liable. Okay. Constitutional requirements under defamation is New York Times requirements. The New York Times requirements does not affect common law defamation. The New York Times requirements creates a higher bar under certain circumstances. And those circumstances are as follows: where there's a public official, and this is where an individual has substantial responsibility or control over the conduct of government affairs. This includes candidates. Constitutional requirements, New York Times malice may apply to a public figure. This is where there's general purpose. There's different types of public figures. There's a general purpose public figure. This is where the person has pervasive power and influence in society. You have a limited purpose public figure. This is where the party thrusts themselves to the forefront of a particular public controversy. Here they're treated as public figure if defamatory statement relates to their participation in the controversy. General purpose public figure, treated as a public figure. Limited purpose public figure, treated as a public figure in regards to that controversy that they thrust themselves into. Looking at a private individual, generally you don't apply New York Times requirements, constitutional requirements. That's generally common law. However, where there is a matter of public concern, plaintiff is a private individual, the statement by the defendant involves the matter of public concern, the defendant is entitled to limited constitutional protections. It's not a matter of public concern. Plaintiff is a private individual. The statement by the defendant is not a matter of public concern. There's no constitutional restrictions. You can pursue common law defamation. Under defamation, looking at falsity. So truth is a defense, is a pure total defense to defamation. But falsity is in regards to matters of public concern. The plaintiff must prove defamatory statement is false, and it's a matter of public. And this is matters of public concern. The plaintiff must prove defamatory statement is false if the statement relates to a matter of public concern or the plaintiff is a public official and or figure. If the plaintiff is a private plaintiff and it's not a matter of public concern, they're not required to prove falsity. In regards to opinion, opinion cannot be the basis for defamation action unless it implies knowledge of facts. Like, it's my opinion, you're an asshole, right? If I say it's my opinion, you're an asshole, that's not defamatory. It may be defamatory, but it's not defamatory. But if I say it's my opinion, you're an asshole because you did X, Y, Z, then that may be defamatory. You're entitled to your opinion that somebody's an asshole. Looking at fault. In regards to the public official and or figure, this is New York Times malice. This is where the public official and or figure, New York Times malice, the defendant had knowledge that the statement was false or acted with reckless disregard as to the truth or falsity of the statement. Now, fault in regards to a private individual, and it's not a matter of public concern. This is negligence or New York Times malice. A private individual, not a matter of public concern. There's no constitutional requirements and requires at least negligence. And that completes part 9 of torts.